Okay, so the coffee is more interesting than Brexit, which is a deeply disappointing but entirely understandable state of affairs. Ladies and gentlemen, hello. For those of you who can't, I promise it's not me that's drunk. That is wobbling. For those of you who can't see my photograph over there, I am Phillips from South Square, and we are going to talk about the recognition of insolvency proceedings in the EU, UK insolvency proceedings in the EU Post Brexit. And I'm going to kick off by saying something that only an English lawyer probably would say, because we still think that we rule the waves. Quite a lot of restructuring is done in the UK. And if we have a hard Brexit, stakeholders are going to want to know whether or not the restructuring is going to be recognised across Europe. And that's what we are going to discuss. We are going to discuss the recognition of UK insolvency proceedings in the EU after Brexit. Now, I have with me two distinguished panel members who I should introduce. The first on my left is Professor Marta Flores of the Department of Commercial Law of the University Autónoma de Madrid. Marta sits on the technical board of Spain's premier insolvency journal, is the author of several prize-winning scholarly articles. She also has several years of experience in practice, including at Baker & McKenzie in Madrid. To her left is Robert van Galen. He is the head of the Insolvency and Restructuring Group of NautaDutilh. He said to me that he's been in practice for a very long time and a member of III for a very long time. And when I asked him what should I say about him, he said, well, just tell them I enjoy playing Chopin. Now, last year, Riz Mokel, who is modestly sitting at the front, Riz and I persuaded III to allow us to pursue what we call Project EU 23. 23 because there are 23 EU member states who have not adopted the UNCITRAL model law. Over the past year, Riz has sent a survey to insolvency specialists across several EU countries. The questionnaire is in your materials. What we asked was how different UK insolvency procedures would be recognised in their jurisdictions after a hard Brexit. There is no doubt from the responses we've received so far that a hard Brexit is going to affect how UK insolvencies should be structured in order to minimise the risks of non-recognition in various EU jurisdictions. Now, Marta and Robert authored the Spanish and the Dutch responses to the survey, to the project. After Brexit, the United Kingdom ceases to be a member state and becomes a third country. The EU insolvency regulation and the Brussels regulation will cease to apply. One suggestion was that the question whether the EU 27 will recognise UK proceedings is simply a question of turning the clock back and applying the law in each EU 27 country that applied before the EU insolvency regulation had been introduced. What that simplistic analysis fails to recognise is that the EU insolvency regulation is now part of the domestic laws of every one of the present 28 countries, and certainly of the EU 27, and their domestic laws and their attitudes have become more pro-recognition. The UNCITRAL model law is also of limited assistance because it has only been adopted by Greece, Poland, Romania, and Slovenia. And that leaves amongst the 23 countries a number of European states in which the recognition of a UK insolvency is going to be pretty important. I'm not going to say too much about the politics. I'm just going to say simply this, and this is obviously a personal assessment, but it is based upon what is going on at the moment in the United Kingdom. The United Kingdom will in all probability leave the EU on the 31st of October or shortly thereafter without a deal. There are a number of reasons why I say that, and I'm happy to discuss them later, but we don't have time at this point. The UK position in that scenario is as follows. The Withdrawal Act, oh, sorry. Right, that's what we're going to be talking about. Right, here we go. Turning back the clock, the EU Withdrawal Act of 2018 provides that direct EU legislation, so far as operative immediately before exit day, forms part of the domestic law on and after exit day of the UK. However, it also provides that the UK government can amend EU legislation. And in the context of insolvency, the UK government has done just that. The Insolvency Amendment EU Exit Regulations of 2018 would amend the EU Insolvency Regulation and related legislation. It's very simple to understand what it will do. It takes a wrecking ball to the system of jurisdiction and recognition of insolvency proceedings. They would all be repealed in the United Kingdom. In its place, the United Kingdom would take an additional ground of jurisdiction over a debtor where either the debtor's COMI is in the UK or where the COMI is in a member state and there's an establishment in the UK. The UK will continue to take jurisdiction where the company is registered in the UK and where there is a sufficient connection in the case of winding up and schemes. Recognition of EU proceedings into the UK will be done under the model law, which means, of course, that is no longer automatic, and the English courts might take a different view of the COMI to the EU courts, although I predict the English courts will take a lot of persuasion to take a different view of COMI than a view that is or looks likely to be taken in the EU 27. So, against that background, in the case of UK administrations, CVA and liquidations, which is the first part of what we're going to look at, the second part is going to be schemes. So I would like, if I may, to turn first to Marta. In the context of administration, CVAs and liquidations, how would a Spanish court approach recognition of one of those UK insolvencies?
Yes, before I start, I would like to heartily thank the International Insolvency Institute for inviting me to participate in this panel today, and also for my admission to the NextGen program. For me, it's an honor. Thanks also to my dearest mentor, Professor Ignacio Tirado, and to my dear and supporting friend, Ruiz Mocal, from whom the invitation to participate came. Although I'm really happy to be here with you today, I have to admit that being a convinced Europeanist, I am not equally pleased by the topic of the panel. But anyway, getting back to your question, Mark, for the sake of clarity, Robert and I have divided the UK insolvency proceedings into two groups, so we will address them separately. Starting with Group A, administration winding up voluntary agreements and bankruptcy, once the European insolvency regulation, the recast, is no longer applicable, the domestic rules on the recognition of insolvency proceedings will apply, concretely the Spanish Insolvency Act. Now, contrary to the recast's automatic recognition, the Spanish Insolvency Act establishes a mixed model depending on the nature of the judgment to be recognized. In this sense, the recognition of the opening judgment must proceed through an exequatur, while further judgments issued on those proceedings will be automatically recognized. So the key element here is the recognition of the opening judgment. This may cause a huge problem when there's no court order whatsoever, as happens, for example, in the so-called paper administrations. So anyway, the recognition of the opening judgment will be granted if certain conditions are met. I have to confess that my biggest fear today is to bore you all to death mainly because I would need to go through procedural aspects of the Spanish legal system. But don't worry, I will not go through the details of each condition. I will just focus on the ones that may cause more problems. As I was saying, the recognition of the UK proceedings will depend on the fulfillment of certain requirements. Firstly, the proceedings ought to be collective. That is to say, they must involve the participation of all creditors. Therefore, selective proceedings, such as voluntary agreements, might be rejected under this regime. Secondly, the proceedings must be based on the insolvency of the debtor. There is a current debate in Spain on whether this includes also pre-insolvency proceedings. Depending on the rigor with which the Spanish court applies or interprets this condition, problems might arise when the debtor is not yet insolvent, but is merely or imminently approaching this state. Thirdly, the proceedings must entail the control or supervision of the debtor's assets and liabilities by the court. This may also pose a problem in those cases where the court's oversight is limited to the arrangement process, but does not cover more generally the company's assets or liabilities, as happens again with voluntary agreements, and of course also in the cases when there's no court oversight whatsoever. Fourthly, for the judgment, the opening judgment to be recognized, it has to be a final one. This means that an interim order, for example, would not be eligible for recognition. And finally, the jurisdiction of the UK court will have to be based on the debtor's comi, on the existence of an establishment, or on a reasonably related connection of an equivalent nature. The law does not provide any example of what these reasonably related connections might be. The location of the registered office could fall within the definition. However, I have serious doubts with other criteria. In my view, at least, the location of significant assets in the UK or the fact that debt is governed by English law would not suffice as grounds for getting jurisdiction. So in short, answering your question, Mark, arguably almost all of these proceedings, the proceedings included in Group A, would be recognized in Spain following a hard Brexit. However, this recognition would be more time-consuming. As an example, the average duration of an exequatur procedure before the courts, the commercial courts of Madrid, is from 8 to 10 months. It would also be more expensive due to lawyers' fees, and it would also be more risky because it is impossible to ascertain in advance the rigor of the Spanish court when applying the conditions for recognition. In my view, at least, an increase in uncertainty is to be expected.
Well, thank you very much, Marta. And just to make sure that I've understood that correctly, where we've got a case where, for example, the European 27 take the view that the COMI of a particular company is somewhere in Europe, notwithstanding the fact that it may be registered in the UK and the directors may put in a paper filing for an administration. If it never sees the court, if that process never sees the court, you're telling me there's a risk that that might not be recognized in Spain?
That is correct.
Breathe. Robert, how would a Dutch court approach the recognition of a UK insolvency in Group A? Oh, you need that.
Well, Mark, thank you very much. Let me see whether... I will start by saying something about Dutch case law, as a recognition of foreign judgments in the Netherlands is not a matter of the statute, but of case law. We have two landmark cases in the Netherlands in this respect, and those are the Gazprombank case and the Yukos case. Both have some relation to Russia. The Gazprom Bank case is generally applicable to foreign judgments, and the EU Post Brexit case, as I would say, concerns bankruptcies. It is important to note that those cases are about recognition, but the idea is that recognition is automatic. So if a party thinks that a case should not be recognized, you should go to court. But the starting point is a trustee comes in. If it's a recognizable bankruptcy, then that trustee can start right away, like, for example, I think is the case in Germany. But we have an exception, and that's in Germany you can open special proceedings over German assets, and in the Netherlands you cannot. Now, the Gazprom Bank case lays down the criteria for recognizing a foreign judgment. And the most important for us here is that the jurisdiction of the court which rendered the decision is based on a ground which is generally acceptable under international standards. And then the three others are there should be a fair trial, there should be no violation of Dutch public order, and a rule about conflicts with other judgments, Dutch or from other jurisdictions. So this judgment applies basically to all foreign judgments from countries with which we have no treaties, in disputes, in commercial disputes, and as follows from the EU Post Brexit judgment, that rule also applies in insolvency proceedings. So, for example, a Russian in bankruptcy in principle, we would recognize it if the jurisdiction of the Russian court is generally acceptable under international standards. However, there are, with respect to bankruptcies, some limitations, or one, that's the so-called territoriality doctrine. That's an old doctrine from our Supreme Court, for which I listed two cases. And basically those cases say that individual creditors can still enforce their rights against the assets in the Netherlands if there is a foreign proceeding until those assets have been sold. And the other one is that a discharge of the debtor and probably also a reorganization plan reducing the claims of the creditors is not effective in the Netherlands. These cases precede the Gazprom Bank EU Post Brexit cases, and I think it's not sure whether they will be upheld if those questions arise again, because basically our Supreme Court now has created a new system of recognition, but that's difficult to predict at this time. So if we look at recognition of UK bankruptcies after the Halloween departure, the basic question will be whether the COMI is in the UK, because if that is the case, I think the Dutch courts will come to the conclusion that the international standards requirement has been met. If the COMI is not in the UK, then it's questionable whether recognition beyond territorial proceedings in the UK will take place. I should add to that presently we have the insolvency regulation and the Brussels I regulation that deal with jurisdiction and recognition. And I think that it is questionable whether the Dutch courts would be prepared to recognize UK insolvency proceedings after this departure to a larger extent than they would do now under the insolvency regulation and the Brussels I regulation, because basically that would mean that you would give a premium to the defecting party, and I think that would that would meet resistance. So I think as a general rule, I think that we may assume that the Dutch courts will continue basically applying the rules that now apply in the inter-European situation. But the main difference is that right now the Dutch court have to accept the jurisdiction of the English court if the English court have opened the proceedings, and after the departure, the Dutch courts will have to evaluate whether the COMI is in the UK indeed, like, for example, under the UNCITRAL model law. I think the other two issues will not play. Fair trial and public policy. Well, there is a lot of faith in the Netherlands in the English legal system, so that will probably be very, very exceptional. But as mentioned, there may be an issue of territoriality. So I make two notes. One is, as I said, in the post-Brexit situation, the Dutch court will no longer be held to comply with the UK decision on jurisdiction, but you will have to make their own appraisal, like under the model law. And two, our present system of recognition has two drawbacks. One is the system of automatic recognition, which entails that the courts will have to determine ex post whether actions of the foreign insolvency representative are valid. And in the UCO's case, that took 13 years. So, but okay, it was a complicated case, but nevertheless. And then the possibility of limitations by the territoriality principle. And I think the Netherlands should adopt the UNCITRAL model law because that would resolve a lot of these issues. Thank you.
Thanks very much, Robert. And I hope you're all picking up that there is a difference in approach. What we're seeing in Holland is less emphasis on the existence of a court order, but we've got the COMI point. Now, just to make it clear, in the UK, in relation to those particular procedures, we will take jurisdiction domestically in much broader circumstances. And indeed, the amendment we're making to the regulations will give us jurisdiction in circumstances that go beyond the COMI. So in relation to the Netherlands, we've got a mismatch between COMI cases, which are relatively straightforward, and the wider jurisdiction that we might take in the UK. And I'll ask the judges from England who are here shortly, that how they're going to react when they are told that they've got jurisdiction under UK law, but in some jurisdictions, for example, in Holland, because the COMI isn't in the UK, there may well be difficulties actually getting recognition of those proceedings, and that's very difficult. But anyway, before we do that, let's move on to schemes, because schemes of arrangement, of course, there are two relevant regulations. We've got Brussels and we've got Rome I. Now, Brussels will fall away on a hard Brexit. Rome I won't, because we're a third-party country and it applies to third-party countries as well as member states. And so if I can turn back to Marta, now we're in Group B, we're looking at schemes of arrangement. Marta, how would Spanish courts approach the recognition of a scheme?
Yeah, nowadays there are 4 options. Theoretically, at least, there are 4 options in Spain for the recognition of a scheme. Brussels I, Rome I, the Spanish Insolvency Act, and the Spanish Act on International Cooperation regarding civil matters. All of them entail any kind of problem. But anyway, once Brussels I is discarded after Brexit, we will be, the second option would be Rome I. Now, let me start by saying that the recognition of schemes under Rome I is not peacefully shared by Spanish academics. The problem with the application of the Rome regulation is that the effects of the scheme can be extended to dissident creditors. In other words, schemes allow for a cram-down. And according to the majority position in Spain, the cram-down mechanism would not easily reconcile with their pretended contractual nature. Indeed, it is understood that for an obligation to be contractual and therefore subject to Rome I, it ought to be voluntarily established between the parties. The other cases, that is to say, where the parties have not consented freely and voluntarily, are thought to be left aside of Rome I. Again, this is the majority position in Spain. There's a minority position who says otherwise. Nevertheless, if the scheme, the specific scheme to be recognized, did not include an extension of effects to dissident creditors, maybe because there are no dissident creditors at all, then it could fit more easily under the category of contractual obligations and hence be recognized under Rome I. Anyway, with these precautions, after Brexit, the recognition under Rome I would still be possible in Spain. Indeed, even if the UK, as you just pointed out, even if the UK left the European Union without a deal, Rome I would still be applied by Spanish courts as its application is universal for us. So Spanish courts would recognize schemes provided that they refer to debt governed by English law, irrespective of where the debtors' comi is located. On the contrary, the scheme would not be recognized with regard to debt governed by Spanish or other foreign law. Now, this can actually lead to a very confusing situation if the scheme refers both to debt governed by English law and to debt governed by other law, because then the recognition should be partial, and I'm not even sure that Spanish courts would accept that. Anyway, there are two other options for the recognition of schemes: the Spanish Insolvency Act, which I just explained, and the Spanish Act on International Cooperation regarding civil matters. Among many other problems, both require that the jurisdiction of the UK courts is based on the comi or on the existence of an establishment, and therefore any other connection might not suffice. So, as a general conclusion regarding schemes, the impact of a hard Brexit is extremely uncertain. There's currently enough confusion and debate with their recognition, but I think it is safe to say that if neither the comi nor an establishment are located in the UK, then the recognition of schemes might